Welcome to Canadian Justice. I'm Christine Van Geyen, and today we're discussing a case that was recently before the Supreme Court in Canada. It's about the defense of extreme intoxication. If a person becomes so impaired by drugs or alcohol that they don't know what they're doing, that they're essentially operating as an automaton, is that a defense for crimes they commit while in that state? That's what the Supreme Court was recently asked to rule on in two cases, Sullivan and Chan. In the first case, Thomas Chan was a high school student who took psychedelic mushrooms. While in a state of delirious psychosis, he broke into his father's house and fatally stabbed him, and also grievously injured his father's partner. He'd previously had a good relationship with his father. Chan was charged with murder, attempted murder, and aggravated assault. In the second case, David Sullivan had been prescribed a drug called Wellbutrin to help him stop smoking. Psychosis is a known side effect of the drug, and Mr. Sullivan began experiencing psychosis. He tried to take his own life by swallowing between 30 and 80 tablets of the drug, but instead fell into a psychotic state and stabbed, but didn't kill, his own mother. Both Sullivan and Chan argued that they were in an automatastic state when they committed their crimes, and argued that this is a defense against the charges. Here today to talk about the case are three lawyers, Connor Bildfell, Jordan Gold, and Ari Goldkind. Thank you so much for joining me today. Sorry, or Ari Goldkind. I usually get your name right, but...
You do, but I forgive you.
Ari, why don't we start with you? That's my high-level description of the case. Anything you want to add to that?
I think before we get into the nuts and bolts of the law of it, this is a case that has largely become a scandal because of the way the media has conveyed it. It's become a case that has attracted headlines because there's this misperception. It's false, it's fake, that somehow people who go drinking and drink like fish are going to start getting away with rape and sexual assault in this country, and that it's going to be open season on women, the rights of women, constitutional protections of women to be free from rape and sexual assault. This case, quite frankly, has nothing to do with it. It's been misunderstood. It's been misapplied by people who don't know the issues, haven't read the issues. And when you dial down into the Sullivan and Chan cases, why they're together, what they stand for, and why they're the right decision, and why I expect the Supreme Court to completely side with the facts that the Court of Appeal of Ontario were right, that you can't take away a viable defense from an accused. I just think it's the telling of these stories in the media that have led to the fallout rather than anything to do with the legal issues at play, and I'll stop there.
So, Jordan, turning to you, part of the issue here is that the Parliament enacted a law that said that you can't claim this automaton state as a defense, this extreme intoxication, if you did it to yourself. It's one thing to say, you were an automaton because you were sleeping and you didn't know what you were doing while you were sleepwalking and you committed a crime. It's another if you became so impaired by drugs and alcohol that you got into this state. So what can you tell me about Parliament's law saying this?
Well, that's right. I think that their Parliament's purpose ostensibly was to hold people accountable and to protect potential victims when the automaton state was brought about by self-induced intoxication. One of the problems, I'm sure we'll get into this, but essentially it's targeting actions that were not necessarily voluntary. It will include actions that were not voluntary, that being the violence that may ensue based on voluntary consumption of an intoxicant. So it's really sort of misguided in terms of what it is that the person needs to have done voluntarily, as opposed to what they're being convicted and punished for.
Now, Connor, is there anything you want to add to this conversation, to my description of the case?
Sure. Just to build on what Jordan was mentioning, just at a very basic level, criminal code offenses have two aspects to them. The first is a mental component, and the second is an action component. And in order for the Crown to prove that an individual has committed a criminal offense, they have to prove both of those aspects. So both the mental component and the action component. Now, it typically isn't enough to simply prove that somebody has done something. There usually has to be a mental element that is attached to the doing of something. So, for example, The Crown may have to prove intention. That is that the person actually intended to commit the prohibited act. One of the issues that this law runs into is that it removes that requirement, that mental aspect
Connor,
of the offense.
I've got to stop you, but we're going to pick that up after the commercial. Welcome back to Canadian Justice, where we're discussing the defense of extreme intoxication and when it should be available. Now, in the last segment, Connor, you were explaining to us the basic concepts of actus reus, mens rea, and how in this case, in the case of extreme intoxication, if a person's operating as an automaton, they don't have the necessary mens rea, the guilty mind, to have committed the offense. But there's actually something lacking in the actus reus as well, voluntariness. So what can you tell me about that?
That's right, Christine. So the idea of voluntariness comes back to this idea, which is a fundamental underpinning of the criminal law justice system, which is that people should be held accountable for their acts only when they do those acts voluntarily and with knowledge of what they're doing. Now, if somebody has entered into a state of automatistic behavior, they're unable to appreciate the nature and consequences of their acts or even what they're doing. Well, that it raises some real issues about, can we hold this individual culpable, criminally responsible for their actions when they're in this state?
Now, Jordan, I want to get into what this means, this automaton state. What does it mean exactly to be an automaton? It obviously, you have to prove more than just saying, hey, I was drunk, I didn't know what I was doing. But what actually do you have to prove?
Well, to be an automaton, it means a lot more than being, uninhibited by drugs or alcohol. It means that you're so intoxicated that your behavior is involuntary, right? That you're capable of action, but you're not conscious of what it is that you're doing. It's your mind is sort of disassociated from the action, and it's really an involuntary act. And you're right in saying it's also takes more than just saying I was in that state, I didn't know what I was doing. You need to, as an accused person, and you have the burden to prove it, right? You need to call expert evidence, that's scientific evidence, to say that in your particular case you were at that extreme level and nothing less, to avail yourself of the defense.
Now, Ari, I have to admit, I understand the policy rationale. There was a case in the 90s that this law arose out of, this law saying you can't claim automaton if you did it to yourself, if you got so impaired by drugs or alcohol. I understand why Parliament would want to say that, because we don't want to let people get away with a crime, a terrible crime, because of something they chose to do, because they chose to put themselves in a dangerous mental state. So what can you tell me about the policy rationale and what you think the court might think about that?
Well, I think the Supreme Court now is going to hold up what the courts of appeal did, which is to say you can't close the door to this defense, that Sullivan and Chan, particularly Chan is the much stronger case of the two, in my view, that he's not a criminal. There's no reason for him to have a criminal record. What he did, and I think people should understand what we're talking about, because it makes it clear. Mr. Chan had a number of concussions as a rugby player. He had no criminal history, no issues with his parents, no issues whatsoever. He was a citizen like the four of us. I mean that literally. He took some psilocybin, some magic mushrooms. They didn't have an effect on him. He was partying. And because of the chemistry of his brain, it mixed in a way that sent him into such a murderous range where he did things that are so violent, I don't even want to say them because they're too violent. There was no dispute, not even by his trial judge, that he was not in his right mind, that he had no idea what he was doing, and that he shouldn't be found criminally liable. So what happened in the 90s, to your question, Christine, is that there was a case called Davio where a man in his 70s drank himself into oblivion, and he ended up sexually assaulting a 65-year-old woman in a wheelchair. Because at the time, people, again, misunderstood a lot about this, Parliament created a rule to say, if you drink, it's the act of drinking that is where the buck stops. If you drink yourself into oblivion, you're responsible for everything that comes next. Now, that's a very appealing thought to a majority of the population who don't really understand the way the law is supposed to work. You're only supposed to punish people for what they've actually intended to do. Parliament said, well, if you don't like what we're doing, somebody will challenge it in the next 5 years. Don't worry about it. If it's a bad law, it'll get challenged. It doesn't get challenged until Sullivan and Chan, because, and here's the key to this never happens where somebody comes to court and says, I'm an automaton, and you get the expert witnesses, which you need to call, you need to pay for, to all agree that this person is an automaton. So for all of these headlines, and I'll again pause my answer here, that it's going to be open season, it's going to invite this, it's going to invite the drunks at the local bar to do this. The reason we haven't talked about this since the 90s is because it doesn't happen.
We've got to go to commercial, but we'll be right back. Now, Jordan, in the last segment, Ari gave his opinion that he thinks the Chan case is the stronger of the two. I introduced both cases. In the Sullivan case, though, Sullivan had taken a drug he'd been prescribed by his doctor, and that smoking cessation drug gave him psychosis, which led to a suicide attempt, and then turned to him attacking his mother. What's your view on Sullivan as compared to Chan and the strength of the two cases? Because in the Chan case, he took the drug recreationally. What other things are happening on the fact level here?
Well, you're right that Mr. Chan did consume the mushrooms voluntarily, but ultimately in both cases, neither man took a drug in such a proportion that you would expect to have the reaction that either of them had. So, although one of them was a suicide attempt, the other one was recreational drug use. There is a big difference between, voluntarily getting yourself to a dangerous state and taking a drug that may or may not be illegal, but with no reasonable foreseeability that you would get to a dangerous state of intoxication. Never mind, no foreseeability that you would go ahead and commit a violent act.
So Connor, similar question. Why is it that these two cases, which I see the similarities, but they do have some big differences, why are they being heard together?
Well, that's a great question, Christine. I think that there are material differences between the two cases, including the nature of what happened when the two individuals took the intoxicants in question. But both cases do raise similar issues. And those issues relate to the constitutionality, the purpose of this provision. And so the Supreme Court of Canada, this case actually came through the Ontario court system sort of in parallel, side by side. And so the Ontario Court of Appeal heard the two cases together. And so it made its way up to the Supreme Court of Canada together as well.
So Ari, there are constitutional arguments being made here. What exactly are they? What is it that Sullivan and Chan are saying is unconstitutional about this part of the criminal code that makes it, the defense of automatism unavailable if it was self-induced intoxication?
It's a very simple argument at its core that Parliament back in the 90s, to address the fallout from the case I described prior to the break, put in a change that was unconstitutional. We don't punish people for things that they don't have a guilty mind for, things that they don't intend to do when they don't even control their own bodies. They essentially prevented a viable defense. Doesn't mean it's going to win, Christine. This is the key that people forget. It doesn't mean the defense will win. But when Parliament takes away somebody's right to make fair answer and defense, and full answer and defense, and by the way, when Crown experts, let's not forget this isn't some defense-y thing where somebody shipped in, from Timbuktu to say, this is our theory. But when the Crown experts agree that somebody's not in control of themselves, the constitutional argument was very simple. We don't live in a country where we punish people for a rape, an attack, an assault, a general intent offense. We don't punish them for drinking and give them a sentence for the offense. We punish people for what they actually intend to do. And again, that's the core of the constitutional argument, which is in this country, we punish the morally guilty. We don't call people criminals or put people behind bars that are not criminals. That's the argument at its distilled core.
Now, Connor, you were involved in the case with representing an intervener called Advocates for the Rule of Law, and you also made constitutional arguments that were slightly different from what Ari's described. What were your arguments in about a minute?
That's right, Christine. So with Jordan Honigman, we represented Advocates for the Rule of Law on an issue related to declarations of constitutional invalidity. And at a very basic level, there's a provision in the Constitution that says the Constitution is the supreme law of Canada, and any law that is inconsistent with the supreme law of Canada is of no force and effect. Now, this issue arose in this case because back in 1999, in a case called Regina and Dunn, the Ontario Superior Court actually struck down this law. It found that the law was unconstitutional and declared it of no force or effect. The issue that arose in this case, in Sullivan and Chan, was whether that declaration was binding on the Superior Court. That is, the Superior Court simply had to follow the decision that came before it. That issue was litigated at the Superior Court level. It was litigated at the Ontario Court of Appeal level. And now it's before the Supreme Court of Canada, who will decide really what is the nature and scope and effect of the Section 52 declaration.
We've got to go to commercial, Connor, but we'll be right back.
Thanks.
Welcome back to Canadian Justice, where we're discussing the defense of extreme intoxication or automatism and when it should be available as a defense for crimes. Now, Jordan, the case is at the Supreme Court, or the cases are at the Supreme Court. So what options are available to the court? What could they do?
Well, the court could interpret the law. They could strike it down. I think in this case, it's a little bit difficult to sort of read into the provision as it's written, this notion that it's the drinking itself or the taking of the drugs themselves that are the offense that are being targeted. That seems to be the argument that the Crown was trying to make. It's constitutional because we're holding people accountable for the act of becoming extremely intoxicated. In this case, that's just not what the provision That's not what the provision says. The provision says that it is the act of violence that is the offense, and that's not constitutional because that act can be not foreseeable or involuntary. If the law is struck down, the Parliament can rethink this. They could pass a law saying that getting yourself to a state of extreme intoxication, even if whether you kill somebody or fall asleep, that in and of itself is an offense. That's not what this law does as it's written.
So, Ari, if the law is struck down, as Jordan said, what do you think Parliament might do? Obviously, this law was enacted in response to that other case that we talked about, Davio, involving self-induced intoxication. So might Parliament revisit the law, change it slightly, and reenact it in a way that might be more constitutionally compliant? Or is there no way of making a law like this compliant with the Constitution?
I think this is going to be struck down, Christine, in short order. My hope is that it's not done in judicial legalese. I hope that whoever writes this decision, and if you look at questions from the bench during this hearing, they were pretty ticked at the Crown, at the state for this. They made the obvious point that this was from the 90s about booze. Sullivan and Chan doesn't even scratch the surface of booze or sexual assault. If you look at the questions, which are often an indication, not necessarily, I think this law is going to be struck down full stop. Now, to your question of what will Parliament do? I don't think they'll do anything. And if they do, I think it'll just be an invitation for it to be slapped down again. I think Parliament's job is to actually understand the laws that people are complaining about and not simply respond to Twitter. Parliament doing its job should advise people, go through the numbers of where these defenses and how many of these defenses actually happen and hold any water in court. Ask any criminal lawyer in Canada if they've brought one like this. They're as rare as the dodo bird and perhaps even rarer.
Well, I don't think anyone should ever respond to what they read on Twitter, let alone Parliament or the courts. It is not a nice place. Connor, your take, what do you think is going to happen here? And I'd be interested in particular on your insight into the possibility of a judicial rewriting of this law.
Sure, Christine. So one thing to understand is that it is always difficult to predict what the court is going to do. At the hearing, the court did express some serious concerns about the way that the provision was drafted, its scope. It does have a very broad scope, and that was troubling the court. In terms of judicial rewriting, the court's role is not to rewrite legislation, and its job is to be, the guardian of the Constitution. If the law is unconstitutional, typically it will strike the law down. And so what the court will be tasked to do is to interpret the provision and determine whether it's in accordance with the Constitution or not.
Well, I definitely agree with you there, Connor. I want to thank all three of you for coming on today and sharing your insight into these cases. It's not such light material. It's some pretty heavy-duty stuff. So I really appreciate you coming on today to share your expertise.
Thank you.
Thanks, Christine.
We've heard today about the defense of extreme intoxication or automatism and two cases that are currently being considered by the Supreme Court of Canada. Whatever the court decides about the case, in my view, they should refrain from rewriting the law themselves and leave that for Parliament. The case involves extremely important and competing values, and although these two cases did not involve sexual assault, the result could have implications for sexual assault cases. But what do you think? Should the defense of automatism from extreme self-induced intoxication be available as a defense for serious crimes? Should it be available in these cases? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.